wonder where Madame Bensouda is.
Welcome participants from around the world to our webinar on World Heritage, Human Rights and Accountability, and welcome to our illustrious panel. We are grateful that they have accepted our invitation. In the lead up to the 50th anniversary of the adoption of the World Heritage Convention, the UNESCO Chair in International Law and Cultural Heritage at the University of Sydney, University of Technology Sydney, with partners from our World Heritage Initiative at the University of Pennsylvania and Duke, are hosting a series of webinars on the theme of World Heritage and Human Rights. Links to earlier webinars will be made available to participants via an email after this event, and will be provided with information about upcoming events also. This webinar on accountability for human rights and humanitarian law violations and World Heritage and protected sites is an opportunity to review and reflect on the operation of the World Heritage Convention and its governance framework within the broader development of international criminal law and international human rights law since 1972. Developments which placed renewed focus on the objectives and functions of the World Heritage Framework and its role in realising the mandate of UNESCO to further universal respect for justice, the rule of law, and for human rights and fundamental freedoms. Each one of our panellists will provide a unique insight into differing modes of accountability in respect of gross violations of human rights, including the important role being played by international criminal courts, the UN's primary cultural organisation UNESCO, and regional human rights tribunals. Panellists will be presenting for 10 to 15 minutes. This will enable a period of Q&A at the end of the final presenter's talk. Attendees are asked to pop questions that they may have for the panellists into the Q&A function. These will be put to the panellists at the end of the last presentation. This webinar is being recorded and the recording will be made publicly available after this event. So let me begin by introducing our first speaker, whom we are most fortunate to have with us today, given she is completing her mandate in a couple of weeks. Madame Fatou Bensouda has been the Chief Prosecutor with the International Criminal Court in The Hague since 2011. Prior to this, she has had extensive experience in the field of international criminal law, having worked at the coalface of several international criminal courts. We know that she has undertaken much of this work, particularly in recent times, with great courage and commitment, and we're deeply grateful for this. Her work as ICC prosecutor is especially pertinent for the topic of this webinar. She led the way in seeking the successful prosecution of the first case brought in respect of war crimes against cultural heritage before the ICC in Al-Mahdi, including the judgment, sentencing and reparations order, and more recently in Al-Hassan in respect of crimes against humanity and acts against cultural heritage. If this was not enough, the recently prepared ICC OTP policy on cultural heritage, intended to guide the work of the prosecutor's office, provides a full and rich understanding of the place of acts against cultural heritage in respect of international criminal law and its future development, one hopes it becomes a fitting legacy for her commitment to this field. Welcome, Madame Bensouda. The floor is yours.
I need to unmute. Yes, I'm unmuted. Thank you very much. At the outset, I just wish to thank you, Anna, for organizing this timely gathering. In anticipation of the 50th anniversary of the adoption of the World Heritage Convention in 2020, this webinar provides a fitting occasion to reflect on the achievements and challenges of our combined efforts to ensure the protection of cultural heritage. And exchanges such as these offer valuable opportunities to take stock and explore ways to strengthen this goal through collaboration and contribution from a variety of actors. And the time is opportune. Moreover, as my office is currently finalizing a comprehensive policy paper on the protection of cultural heritage, which will be launched shortly before I conclude my term as prosecutor of the International Criminal Court in mid-June. And I extend my appreciation to my fellow speakers, Mr. Vilal Pando of UNESCO, and Ms. Kabajuni of the African Minority Rights Group, I'm really very, very pleased to share the stage with you today. Ladies and gentlemen, the preamble of the Rome Statute stipulates that all peoples are united by common bonds. Their cultures pierce together in a shared heritage and concern. Cultural heritage is the bedrock of cultural identity, and crimes committed against it often touch upon the very notion of what it means to be human. It is an attack on an essential interest of all humankind and the entire international community. And sadly, as history has shown, willful attacks on cultural heritage are a pervasive feature of conflict and mass atrocities. During the 1990 wars in the former Yugoslavia, countless religious and cultural sites were systematically destroyed in an effort to erase the culture of targeted groups. And in more recent times, there has been grave destruction of heritage sites in Iraq, in Afghanistan, in Syria and Mali, just to name a few. And the protection of cultural heritage has been enshrined in the legal instruments governing various international courts and tribunals, such as the International Military Tribunal of Nuremberg, the International Criminal Tribunal for the former Yugoslavia, and the extraordinary chambers in the courts of Cambodia. The International Criminal Court, too, has a critical role to fulfill in relation to the protection of cultural heritage as the only permanent international criminal court for holding accountable those responsible for attacking or destroying cultural heritage, which may constitute or be part of the commission of war crimes, crimes against humanity, genocide, and the crime of aggression. I firmly believe that the principled, the consistent and effective enforcement of the applicable legal framework, which we have at our disposal, offers an important instrument through which to address and prevent crimes, including those against or affecting cultural heritage. And we have tried to put this belief into practice. The Rome Statute confers the ICC with jurisdiction over crimes against or affecting cultural heritage. Article 8, dealing with war crimes, offers the most straightforward means to address intentional harm to cultural heritage. And it specifically seeks to protect certain types of cultural heritage in armed conflict through the prohibition of intentionally directing attacks against buildings dedicated to religion, education, art, science, or charitable purposes, and historic monuments. It is in this context that my office has most notably advanced its investigation and prosecution work in the situation in Mali. I wish nonetheless to emphasize that my office broadly construes the term cultural heritage to extend beyond cultural property and incorporate both products and processes involving cultural resources in both their tangible and intangible forms. In using the term cultural heritage, we thus recognize that attacks against or affecting cultural heritage may also constitute or relate to other crimes under the statute, and thus more properly reflects the rich corpus of human achievement that the statute and international law seeks to protect. In Mali, my office has been conducting investigations since 2012, following the referral by the government. And during that time, the north of Mali had fallen into the hands of jihadist groups, such as Al-Qaeda in the Islamic Maghreb and its affiliate Ansar Din. And as part of the insurgency, attacks were launched at Timbuktu's mausoleums that were protected by international law and by the Rome Statute as buildings dedicated to religion and historic monuments. Recognizing their centrality to the conflict, my office's investigative and prosecutorial efforts focus firstly on these incidents, and we managed to do so through the Al-Mahdi case in September of 2015. Mr. Al-Mahdi was the head of the Hizbah, the morality brigade of Ansar Din, which had a central role in the attacks on Timbuktu. We deemed Mr. Al-Mahdi's prosecution to be critically important, The structures destroyed under his supervision were not only important to Mali from religious, historical, and identity point of view, but to the whole of Africa, and indeed the entire world. And in deliberately deciding to bring a standalone charge against Mr. Al-Mahdi for attacking protected 9 mausoleums and 1 mosque in Timbuktu, my office aimed at stressing the importance of this crime and stigmatizing the necessity for accountability, not only for deterrence interest, but also the recognition of victims. Excuse me. And during this trial, Mr. Al-Mahdi pleaded guilty to the war crime of intentionally directing attacks against buildings dedicated to religion and historic monuments. And on 27 September 2016, the trial chamber of the court unanimously found him guilty beyond reasonable doubt as a co-perpetrator of the said war crime. He was sentenced to 9 years of imprisonment. The case sent a strong message that the intentional targeting of cultural heritage is a serious crime under international law, affecting both the local as well as the international community as a whole. This message was recognized and reverberated through a variety of international actors, including UNESCO. We had worked very closely with UNESCO on the case in the exercise of our independent but mutually reinforcing mandates in the context of this case. And building on that partnership, we have entered into an agreement with UNESCO to further institutionalize our relationship and look to capitalize on synergies of mandates. We are proud of that partnership. And given the strong demands for our intervention, my office's work in Mali and in relation to protecting cultural heritage through the Rome Statute framework has since continued. In a second case in this situation, that against Mr. Al-Hassan, my office has equally brought charges relating to the attacks against buildings dedicated to religion and historic monuments in Timbuktu, in addition to other charges of war crimes and crimes against humanity, including rape, sexual slavery, forced marriages, and persecution based on gender and religious grounds. In relation to the latter, we have brought the charge of religious persecution as a crime against humanity to capture not only attacks against mausoleums, but other attacks against cultural heritage, including non-tangible heritage in Timbuktu, such as banning of some religious practices, in addition to amulets, talisman, and statuettes. And this case is currently ongoing. It is my firm belief that accountability is a crucial aspect to ensure the protection of cultural heritage. My office is committed to continuing investigating and prosecuting relevant crimes in any situation under the ICC's jurisdiction. In accordance with this forthcoming policy, the office will keep seeking to address alleged crimes against or affecting cultural heritage in all stages of its work: preliminary examinations, investigations, prosecutions, and when so invited and as appropriate, will contribute to the representations and the submissions and views at the stage of reparations proceedings. We are currently finalizing the policy following a productive round of written consultations with states parties, international organizations, civil society, and other stakeholders. With the adoption of the policy, we hope to further strengthen the protection of cultural heritage by addressing the numerous ways in which crimes within the jurisdiction of the court affect aspects of human heritage, and finding ways, including by collaborating with other partners, to effectively address this scourge. The policy aims to provide clarity and guidance to staff of my office in the application and interpretation of relevant provisions of the Rome Statute and the rules of procedure and evidence. The policy text, which I should add on this occasion, contains also several references to the World Heritage Convention as an important additional source of assistance with regards to principles and rules of international law relating to cultural heritage. The policy additionally aims to, amongst others, promote the work of and to support partners, including states, with the view to creating networks and synergies to coordinate efforts to protect cultural heritage and to prevent and prosecute related crimes globally. Also contribute through its implementation to the ongoing development of international jurisprudence regarding crimes against or affecting cultural heritage, and also to raise awareness regarding the importance of the protection of cultural heritage, including to support genuine national proceedings. My office recognizes that no actor alone is able to effectively fight impunity, including for crimes against cultural heritage. An effective strategy to address the destruction of cultural heritage requires a multifaceted and collaborative approach while respecting each partner's mandate and independence. Relationships with external partners have already greatly empowered and enriched my office's work, as our cooperation with UNESCO has shown, and we will continue to consult with external partners on how to maximize our contributions to the protection of cultural heritage. Ladies and gentlemen, international criminal justice has demonstrated that it works and can work even more robustly for the benefit of humanity's progress if it is increasingly accepted and supported by all stakeholders, primarily the states. Ultimately, international criminal justice with the ICC at its core serves humanity as a whole. It is not exclusive to one people, one place, or one time. Our cultures are pieced together in a shared heritage, and the ICC's protective embrace is for all to enjoy so long as we have the courage to join it, stand firmly by it, and help withstand its challenges. Cultural heritage is the repository of the human experience throughout the ages. It defines our history and identity, past and present, our commonality, and indeed, the richness of our diversity in the garden of humanity. We must protect cultural heritage. And to protect cultural heritage is to protect ourselves. It is to pay homage to a most basic fabric of civilization and civilizational practice. I thank you for your attention.
Thank you so much, Madam Bensouda. Thank you for your talk, but also thank you for your commitment to this area and to the development of international criminal law generally. You'll be missed already even before you leave, but I'm sure that we'll see you in a different role. We hope. Thank you very much again. And welcome Mr. Santiago Villalpando. Mr. Villalpando is the UNESCO Legal Advisor and Director of the Office of Legal Standards at Legal Affairs since 2019. He has previously worked as the Chief of the Treaty Section of the UN Office of Legal Affairs and has also worked, coincidentally, at the International Criminal Court for the former Yugoslavia and also the International Court of Justice. We are grateful that he has taken up this invitation to speak to us today about the possible role that UNESCO may play in addressing the human rights violation on World Heritage sites and also other protected sites. As we all know, the World Heritage Convention was adopted by the organisation's General Conference in 1972. It currently has 194 state parties with over 1,100 properties on the World Heritage list, and currently 53 are listed on the endangered list. Its secretariat, the World Heritage Centre, is located within UNESCO. The World Heritage logo has become globally recognised symbol for protected sites. Mr. Villalpando, welcome, and we look forward to your talk.
Thank you very much. Thank you very much, Anna, and thank you for the organization of this seminar. It is truly an honor for me to be here with you and also to share the panel with such distinguished intervenants. After Ms. Bensouda's very interesting intervention on the specific topic of the International Criminal Court, my presentation will take a somehow more general approach by examining the legal framework of the relationship between world heritage, human rights, and accountability, and explaining the role of my organization, UNESCO, which stands at the crossroads of those topics. According to Article 1 of its constitution, the purpose of UNESCO is to contribute to peace and security by promoting collaboration among nations through education, science, and culture. In other words, as a specialized agency, UNESCO promotes international cooperation in certain technical fields for the pursuit of the same goals proclaimed by the Charter of the United Nations. UNESCO's mandate, however, hides a mystery in plain sight. Namely, what is the relationship between education, science, and culture on the one hand, with the higher purposes of the United Nations on the other? And why is it that the founders of the UN system decided to entrust cooperation in fields as varied as education, science, and culture to one single organization and not to many? And the answer is to be found in a beautiful sentence which introduces our constitution. Since wars begin in the minds of men, it is in the minds of men that the defenses of peace must be constructed. In other words, through its action in education, science, and culture, UNESCO aims at building the defenses of peace in the minds of men and women. Again, according to our constitution, UNESCO aims at building the intellectual and moral solidarity of humankind, which shall support the political and economic arrangements established by the United Nations. And what is interesting here is that this intellectual and moral solidarity was also given some content by the founders of UNESCO. Since our constitution also says, as was mentioned in the introduction, that UNESCO's action aims to, and I'm quoting, further universal respect for justice, for the rule of law, and for the human rights and fundamental freedoms, which are affirmed for the peoples of the world by the Charter of the United Nations. So, the first thing to say is that human rights are not a serendipitous encounter in UNESCO's historic path. They are an integral part of the mandate of the organization, an objective that inspires its entire action. And indeed, human rights are present in all dimensions of UNESCO's mandate. A good illustration of this is the so-called 104 procedure before the Committee on Conventions and Recommendations of our Executive Board, which was established in 1978 on the 40th anniversary of the Universal Declaration of Human Rights. In a nutshell, under this procedure, the committee receives and examines individual communications. Since its creation, there have been more than 700 of those, concerning alleged human rights violations in education, science, and culture. This procedure is distinctive in that it is strictly confidential and not aimed at establishing accountabilities, but rather at finding amicable solutions to the case in a spirit of cooperation and conciliation with the government concerned. UNESCO has also been active in human rights in its different areas of programmatic action. In education, for example, UNESCO has adopted a landmark 1960 Convention against discrimination in education, and the 1974 recommendation concerning education for international understanding, cooperation, and peace, and education relating to human rights and fundamental freedoms, a possible revision of which, by the way, is currently under consideration. In the field of communication and information, UNESCO is engaged in the protection of journalists, both through public statements made by our Director General condemning the killing of journalists, and through the holding of an annual World Press Freedom Day. And in the field of sciences, UNESCO has formulated basic principles of bioethics in its 1997 Universal Declaration on the Human Genome and Human Rights. But of course, our encounter of today is mainly focused on the field of culture and world heritage. And what first comes to mind is the 1972 World Heritage Convention, which was mentioned several times before. Now, the first thing to say about the 1972 convention is that it is not a human rights convention. It does not proclaim any individual or collective rights. It does not establish any human rights protection mechanism. As a matter of fact, its text does not even mention human rights in any manner. The objective of the convention is rather to protect the world's cultural and natural heritage, and it does so notably by imposing a number of obligations on states parties for the protection of such heritage within their territory, and by establishing mechanisms to facilitate international cooperation for its protection, including financial means, educational programs, and technical support. There is, however, an undoubtful connection between the 1972 Convention and human rights. Indeed, the Convention also proclaims that the cultural and natural heritage of outstanding interest is to be preserved as part of the world heritage of mankind as a whole, and that therefore it is incumbent on the international community as a whole to participate in its protection. In other words, world heritage and human rights share the attribute of being public goods, which protection is a matter of interest to the international community as a whole. This allows me to come back to the decisions made by the International Criminal Court, which were so eloquently illustrated by Ms. Mensouda. What I find interesting in the court's judgment in the Al-Mahdi case is the fact that the destroyed cultural sites were on the UNESCO World Heritage List seems to have been instrumental in the conclusion that their destruction was of particular gravity and that it affected not only the faithful and inhabitants of Timbuktu, but also people throughout Mali and the international community. And this is the reason why the court later decided to award a symbolic euro of reparation both to Mali and to UNESCO, which was therefore seen as embodying the interest of the international community as a whole in the protection of those sites. As a matter of fact, the UNESCO Deputy Director General received the symbolic euro in a formal ceremony that was held in Mali, in Timbuktu, back in March, only a couple of months ago. Human rights also plays a role in the implementation of the 1972 Convention. Indeed, if the Convention doesn't mention human rights, the Convention's operational guidelines do. In their protection of the World Heritage properties, indeed, states parties are encouraged to adopt, and I'm quoting, a human rights-based approach, and to ensure gender-balanced participation of a wide variety of stakeholders and rights holders, including local communities, indigenous peoples, and non-governmental organizations. States parties are also encouraged to mainstream into their programs and activities the 2030 Agenda for Sustainable Development and international human rights standards. Finally, human rights issues have also arisen in the 1972 Convention with regard to the possible inscription on the World Heritage lists of sites associated with memories of recent conflicts. A number of these sites are already in the list, such as the Hiroshima Peace Memorial and the Auschwitz extermination camp. And some others have been included by states parties in their national tentative lists for possible future inscription. This is the case of the memorial sites of the Rwandese genocide, or the Argentinian ESMA, a former detention and torture center during the military dictatorship in the 1970s in my home country. In 2018, the World Heritage Committee launched a reflection on whether and how sites of this kind relate to the purpose and scope of the World Heritage Convention, which entails a discussion on the nature of memorialization and the value of evolving memories with respect to cases of massive human rights violations. The committee, by the way, is due to decide on this matter in the upcoming 44th session, which will take place in July. Prior to concluding, I would like to devote a couple of minutes to two other UNESCO conventions, which are, in my view, very relevant to our topic of today. The first one is the 1954 Hague Convention, together with its two protocols, which is the first universal treaty focused exclusively on the protection of cultural heritage in the event of armed conflict. The convention establishes a regime of enhanced protection for cultural heritage in armed conflict and constitutes one of the bases for the recognition as a war crime, as mentioned by Ms. Mensouda in the Rome Statute, of the intentional attack against buildings dedicated to religion, education, art, or science when they're not military objectives. The convention has also recently come into prominence in the aftermath of the conflict between Armenia and Azerbaijan, since the UNESCO Director General has offered recently to the parties the dispatch of an independent mission under the convention to draw a preliminary inventory of significant cultural properties in Nagorno-Karabakh. Lastly, I should mention the younger sister of the World Heritage Convention, the 2003 Convention for the Safeguarding of the Intangible Cultural Heritage. Now, I don't have time to look into this convention in detail, but I wanted to draw your attention to the fact that in defining what intangible cultural heritage is, the convention explicitly refers to human rights. Indeed, according to its Article 2, the convention protects intangible cultural heritage only when, and I'm quoting, compatible with existing international human rights instruments, as well as with the requirements of mutual respect among communities, groups, and individuals, and of sustainable development. This feature came into relevance in 2019, when the Intergovernmental Committee of this convention took the unprecedented decision to remove the Belgium's Aalst Carnival from UNESCO's representative list of intangible cultural heritage, since it had, and I'm quoting from the decision, on several occasions displayed messages, images, and representations that can be considered as encouraging stereotypes, mocking certain groups, and insulting the memories of painful historical experiences, including genocide, slavery, and racial segregation. This latest illustration can easily allow me to conclude briefly on a more general note. And this is that the theme of our today's encounter is of central relevance to the mandate of the organization to which I belong. Human rights are embedded in the protection of the World Heritage by UNESCO, insofar as they are essential to building the intellectual and moral solidarity that shall unite the peoples of the United Nations. Thank you very much.
Thank you very much, Mr. Villalpando, for this broad sweep, which I was not expecting, but also a wonderful bridge between the two speakers. So thank you again, and I'm sure there'll be many questions for you, including from myself. So I look forward to the Q&A with you. So now our final speaker today is Madame Agnès Kabajuni. Ms. Kabajuni is the Managing Director of the Minority Rights Group International Africa. She's also Executive Founder of the Centre for Economic, Social and Cultural Rights in Africa. She's particularly well placed to speak about the role of human rights tribunals in respect of holding states accountable for gross violations of human rights on World Heritage sites and other protected properties. MRGI has led a number of successful actions before the African Court and Commission of Human Rights and People's Rights in respect of large-scale human rights violations on or related to protected sites, including World Heritage listed properties. Examples of their successful advocacy includes actions brought on behalf of the Ojib and Ndroy peoples in respect of their forcible removal from their traditional lands on the pretext of conservation. Although both of these communications were successful, the eventual fate of these actions highlights the difficulties of human rights cases in respect of implementation and accountability. Ms. Kabajuni, thank you for accepting our invitation and welcome. Ms. Cabajuni, I will need for you to unmute.
I'm unmuting, yes.
Yes, thank you.
Can you hear me now?
Yeah, absolutely.
Okay. Okay. Ladies and gentlemen, it's a pleasure for me to be here today, and I'm glad for the invitation for being part of this panel. So I'll address myself to the
We appear to have, oh good. Ms. Cabajuni, maybe I'll turn the video off because it may be easier just with the audio if the connection is difficult. If that is okay for you. No. Ms. Cabajuni, can you hear me? Well, it's on mute. Maybe if you turn your video off and just the audio, it will be easier.
Yeah, I'm having some internet challenges, I think.
Yeah, maybe with just the audio, it will work better for you.
Okay, let me try. So am I heard again?
I can hear you, absolutely hear you. Thank you.
Okay, I will go that way. I'm sorry for that.
No, not at all.
Okay, no problem. Like I said, I will look at the issue of cultural heritage and the perspective of human rights of ethnic minorities and indigenous peoples. And at MRG, we look at the human desire, the pride in the past, to pride in the past, present, future, and that it reinforces human dignity, a strive for identity and recognition, a desire for belonging, and a sense of having a claim on natural resources. The essence of existence, where we look at the spaces and places linked to the very human existence of certain communities. And the culture, religion, way of life, language, symbols, rituals, and economic livelihoods of ethnic minorities and indigenous peoples. So I'll again address myself to two areas we have worked on and protect and where our cases at the African Commission is based on. That is the Mau Forest Complex. The Mau Forest Complex is currently the water table for Kenya, with the several rivers originating from it and serving the wider area of Western Kenya, and that flows into Lake Victoria waters. Also the largest of indigenous mountain forests in East Africa, but also home to the Ogiek people. The Ogiek people are hunters and gatherers, forest people who have lived with nature for centuries. And our case surrounds one of the cases we have of 2017, centers around the Ogiek people. So I will address on that. The second area I will address myself around is the area around Lake Bogaria, which is also part of Kenya's Great Lake system in the Rift Valley, and was once a UNESCO World Heritage List with profound beauty and ecological diversity. So it's an area currently under game reserve, and the Kenya government looks up to for tourism. It is also a home for Endorois people who are semi-pastoralist communities. So our second case at the African Commission is actually centers around the protection of the rights of Endorois people. So I will move on to look at the two cases. The way I looked at my presentation today, I looked at it in terms of our experiences with the cases of the Ndores people. I will begin with the Ndores people and then talk about the Ogiek people. The Ndores people, like I said, are people living around Lake Bogoria in, in the Rift Valley. And this semi-nomadic indigenous community are of about 60,000, and their livelihoods centers around herding cattle and goats on around Lake Bogoria. But these are the people, again, who experienced eviction, massive eviction from this area they called home for centuries, when this area was conserved by the government, first in the 1973 and secondly in 1978. And historically, the Ndores people have used Lake Bogoria and the surrounding areas as a prayer site, as places for circumcision rituals and other cultural ceremonies that culturally, spiritually, and religiously are connected and interlinked to the lake. And the belief that the Ndores people originated from the areas around Bogoria as their ancestral home. But in our case, to the African Commission, we argued that the Ndores people were dispossessed of their land by the Kenyan government through creation of the Lake Bogoria Game Reserve. And these people were not consulted. They never consented to the creation of the game reserve, and they were neither compensated or restituted, and therefore they did not also benefit from the royalties that came from tourism and also the mining activities around the Lake Bogoria. We also looked at issues around that the Ndores people are a people protected under the African Charter as peoples who deserved protection of as a collective people or collective rights. And the government of Kenya breached their right to property under Article 14 of the African Charter with regard to the continuing dispossession of their ancestral land. We also looked at the question of the government of Kenya continued refusal to give community access to the religious sites to worship freely, which also amounted to the violation of Article 18 of freedom of religion, or to practice the religion without unnecessary restriction. We also looked at the violation of the right to culture protected under Article 17 of the African Charter, and because by the creation of reserve and the forcefully evicting the Ndores people, the people could not access sites, their cultural sites for worshiping, for ritual practices, and also their religious practices were also restricted. We also looked at the breach of Article 21 of the African Charter, which guarantees the right to natural resources. The Lake Bogoria provided the Ndores people fertile lands, medicinal salt licks for their cattle, and the grazing rights for their cattle. And by the fact that of preventing them to access this area, it meant a lot in terms of effects on cattle dying in great numbers, on people's faced to face a lot of hardships in terms of accessing grazing resources. And also we looked at a violation of their right to development under Article 22 of the African Charter. And this is a specific issue around, because as a people whose lifestyle evolved around herding cattle and herding goats, preventing them from accessing resources that provided them sufficient grazing grounds and fertile grounds for medicinal salt licks and other issues. It affected their rate of growth and rate of development. And we looked at this in terms of cases, and all these areas of violations by the government were found admissible by the African Commission. And the ruling that came out on the case in 2010 found out that the government of Kenya had violated the people's rights to religion and Article 8, to development and Article 27, to practice their culture under Article 17, and to property, recognition of their ancestral claim over the lands they occupied. And this is significant for the issue of a community that rotates around cultural heritage, pride in the issue of recognition and identity, who identify with the places they occupy. And to this effect, the Endoro's case at the African Commission constitutes one of the major success stories of a case that for the first time indigenous populations in Africa had a chance of being recognized and identified as a people protected under the African Charter. But the sad story about this case that was a groundbreaking case in 2010 is the issue of the implementation by the Kenyan government. Since then, a lot of things have happened in Kenya. For example, a progressive Kenyan constitution of 2010 was passed out. And also in 2016, the government of Kenya passed out also the Communal Land Act, which looks at recognition of communal land and collective rights of the indigenous communities. But this having come up has not in any way benefited the Ndoro's people. The Ndoro's communities still face challenges related to accessing the ancestral lands around Lake Bogoria. The implementation of the judgment and ruling of the case has not been respected by the government of Kenya, and they fall under, for example, issues of compensation and reparations, ensuring that the well-being of the Ndoro's people improves. People benefit, the Ndoro's communities benefit from royalties from the tourism that is taking place around Lake Bogoria, has not efficiently been achieved, and also allowing people to access Lake Bogoria for cultural rights and religious practices have not been enforced. So in essence, the Ndoro's case still remains a success story, but also on the other hand, a case that shows that sometimes the difference between a positive ruling and the implementation of the positive ruling is quite a challenging issue, especially in this regard. So the second case I would address myself on is the Ogiek case. The Ogiek case is a case that was referred to the African Court on Human and People's Rights by the African Commission. We as MRG, together with local organizations, especially CEREMID, Center for Minority Rights and Development, and also the OPDP, Ogiek People's Development Program, did submit this case after efforts to exhausting the local remedies to the African Commission in 2009. And again, the Ogiek people occupy the Mau Forest Complex. It's one of the areas I have talked about as part of Kenya's Great Lake system in the Rift Valley. It's one of the water table of Kenya's water table. In other words, most of the rivers originating from it that are serving the wider areas of Western Kenya. And it's also the largest indigenous montane forest in East Africa. And this is what the Ogiek people call their home for centuries. And the Ogiek people are hunters and gatherers, and forest people as well, who live in the Mau forest and have lived in Mau forest for centuries. What happens is that the government of Kenya, the Mau forest complex is also under the services of the Kenya Wildlife Service, KWS. Who over time, in the event of protecting the water table and the catchment area, the water catchment area, decided to evict the people from the forest as a measure of improving and conserving the water table. But also this is an area, the Mau complex, which covers almost 5 counties of Kenya, is an area that is also with a lot of, where government has given out licenses for logging, to forest logging companies. But also it is an area that government also allowed occupation by other people from other communities, ethnic communities from other areas. And the contentious issue of the Ogiek, the original occupants of this area were ignored. They were not recognized as an indigenous population of this area. And they continued to experience discrimination in terms of accessing the forest, and yet they called it home. And with a lot of evictions going on, and sometimes hostile evictions that involved burning of homes and evicting people in massive eviction of people without alternative resettlement, the people resorted to taking the government to courts without avail. And the local courts in Kenya eventually ruled out that they never had a claim of ancestral ownership to these lands, and the lands that were already now under conservation for purposes of protecting water catchment area. So in 2009, we did with the other communities.
If I could ask if you could wind up, I'm sorry, it's just unfortunately because of the limited time, so that we have a chance to do a question and answer.
I'm bringing it.
Thank you very much. Thank you.
Okay.
My apologies.
It's okay.
Oh, if you'd like to just finish your final comments, and then just so that we can have a few minutes of Q&A.
Am I allowed to go to summarize and finish?
Yes, please.
Okay, with the Ogiek case, we also found out that similarly to the Endoris case, but this being at the African Court of Human and People's Rights, we also, the outcome of the 2017 ruling was that they found that the government of Kenya had violated to the Article 14 of the African Charter on the ownership of the Ogiek ownership of the traditional owned lands. Article 2 on the issue of that the Ogiek suffered discrimination at the hands of government because there were other communities like the Maasai who have been recognized as tribes and consequently have been able to enjoy their rights. On Article 18 of denial of access to Mau forest and the religious sites within it, and failing to demarcate and protect those sites of government interfered with their ability to practice and worship the faith as their faith dictates. We also found out, they also found out a violation on Article 17, 2 and 3, the protection of individual participation of cultural life of the community, and also the right to natural resources, Article 21 and Article 22 on social, economic and cultural development. So literally in my final conclusion, I'm saying that ethnic minority and indigenous people as a custodian of heritage across countries. Their embodiment of cultural heritage through music, dance, and rich languages, through art and crafts, through religious and cultural festivals, and indigenous knowledge. So recognition and recognition of the existence and the cultural claim of lands and the ancestral location is very pertinent to their real existence. So the two cases brought out this specific aspect of the need for identity, the need for recognition, and the need for upholding their rights. And most of the time, governments ignore this particular aspect, which leads to violation of the ethnic minority and indigenous people's claim over these ancestral rights, as the two cases demonstrate. Thank you.
Thank you very much, Ms. Kabajuni. It's unfortunate because of the technical issues before at the start of your talk that you weren't able to have a full time that you were allotted. So thank you very much. And it also bears witness, both of those cases, to what the previous speakers talked about, was not just that the World Heritage sites or properties refer to the physical aspects, but also the importance of the intangible aspects of those sites and the importance of those sites in various practices for those communities. So the floor is open to people to ask questions. I have a few which I will put to the speakers now, if I can, and if we may have a few minutes, and I beg indulgence of the panel and also the participants if there are any additional questions, but I'll put the questions that have been put now to the panelists. So the first question from Dalia Nabil is, and I suspect this is to you, Madam Bensouda, it's a timely one. It's in relation to acknowledging that Jerusalem is World Heritage as well, is whether that could also, what destruction of heritage on that site can be investigated by the ICC. And also somewhat related to this, and it's both to Mr. Villalpando, but also to Madame Bensouda, is in relation to the role of World Heritage, but not just World Heritage, in relation to post-conflict situations. So I'll ask Madame Bensouda to answer, and then Mr. Villalpando.
Sure. With regards to the first question about, well, in this case, ICC looking into the current events that are ongoing in the situation in Palestine, we call it. I'm sure you will know that we have already opened investigations into the situation in Palestine, following the judicial clarification from the chambers, which came sometime in March, and following which I made an announcement that investigations have opened into this situation. You will also recall that this is a situation that has been before my office, I believe since 2015, sorry, and we have been working on it. So where we are now is that investigations have been opened and steps are being taken in my office to effect those investigations. Recently, with the escalation of violence, as you know, I also issued a statement calling on the parties for calm and restraint, but also highlighting the fact that the situation is under investigations, and that during the course of our investigations, the current events that are taking place will be considered will be looked into as part of the investigations of the International Criminal Court. So this statement is out there. I'm sure if you go into the archives, it's very recent, less than 2 weeks ago, you will be able to find that we also have made pronouncements on those, on the current events that are ongoing, and continue to call for calm and restraint. Thank you.
Thank you, Madam Bensouda. Mr. Villalpando.
Yes, I will address in particular the other aspect of the other question that was on post-conflict situations and World Heritage. Now, it goes without saying that, and I think we all are aware of the fact that armed conflict is a threat on World Heritage, and indeed one of the reasons that may lead to the inscription of a site in the list of World Heritage in danger is the existence of an armed conflict that may have an impact on it. What may be lesser intuitive, but not less important, is the fact that the preservation of World Heritage is a way to contribute to sustainable development and conflict prevention and resolution. In other words, this element is truly, as our constitution says, part of peace, of building peace. And in that regard, I would mention an initiative that UNESCO has. It's a flagship initiative today, which is called Revive the Spirit of Mosul. And this has translated itself in a number of initiatives for the preservation of the old city of Mosul, as well as to the reestablishment of educational and cultural and religious, indeed, institutions in Mosul after the war. So the activity of UNESCO in post-conflict situations is present. There's actually a program on post-conflict situations that UNESCO has undertaken for already several years, and which has actually implied intervention in several states, and which contributes through, for example, education in emergencies and reconstruction, natural disaster risk reduction, culture and World Heritage in emergency situations, media in conflict and post-conflict situations, and the promotion of gender equality in crisis situations. And last but not least, I should mention that the 1954 Hague Convention is a convention that is, I would say, as important during armed conflict than as it is within armed conflicts. In other words, in that convention, states parties take a number of obligations in order to prepare themselves through, for example, inventories and the appropriate marking of cultural heritage sites, in order to ensure their protection once the conflict happens and after the conflict has ended. Thank you very much.
Thank you very much, Mr. Villalpando. We have a question for Ms. Kabajuni from Dr. Keki. He wants to know how seriously, and I think those are his words, national courts and lawmakers take the decision of the African Court and African Commission.
Okay, I didn't get the name where it came from. Okay, Chechi.
Yeah.
Yes, thanks for asking that question. To some extent, you can say largely the decisions from the African Court and the African Commission serve, are not taken seriously, if so to say, or ignored by the states, but to the other extent, they kind of serve to hold, one, to throw light into the matter. For example, like the example of the Ogiek case, during the time through which the African Court handled the case, evictions were kind of put hold for the Ogiek people, so they had a relief. But since then, since 2017 to date, this has, first of all, the implementation of the case has kind of not taken off. Secondly, if I can quote of last year, the Ogiek people again were at the threat of being evicted once again. So do the African states take the African court and the African Commission decisions seriously? It's a mixed results, I would say. Most of the time, there is slow in implementation of the court rulings and the tendency of ignoring most of the rulings. Up to now, the Endorwais community case have never been implemented. Maybe again, you have slowness in terms of because maybe states feel they can continue to take measures which are never conclusive. For the Ogiek case, immediately after the 2017 ruling, the government of Kenya constituted the Ogiek case implementation task force. But the task force time period came to an end in 2019 and was renewed thereafter, but it had done nothing. It was supposed to be doing more investigation in relation to going down to the Ogiek Mau and do more assessment of how the implementation would be rolled out. But up to 2019, again, it was its lifespan was extended, and then we had this corona coming in. But still, the follow-up of the task force has been very slow in terms of looking at opportunities to front the implementation of the Ogiek case. So yes, the government responds, but it's a slow pace, and sometimes they ignore. And I want to bring it out to the question of, it's a question of interest at stake. Here we are talking about the issue between the decisions and the government's interest. For example, in the case of the Endorwais case, this is an area that government, that is also a tourism, that is earning the government tourism revenues. And there are also interests of other stakeholders of public investments and individual investments into tourism. So the interest the government has is also in the way whether to implement the case or not. The same thing with the Mau issue. It has to do with the sensitive issues related to land and land issues related to grabbing, but also to fraudulent land acquisition in the Mau area, but also as well as the issues to do with logging, which is also have a political issue in relation to the implementation of the case. I would say that.
Thank you very much, Mrs. Kabajuni. Now, I have 3 other questions, which I would actually, because we are now running over time, I will put one again to you, Ms. Kabajuni, combining 2 questions that we have, and then one which I will direct to both Madam Bensouda and Mr. Villapando. But Madam Kabajuni, there are 2 questions which are sort of related. There's the question in relation to the recently established Indigenous Peoples Forum on World Heritage before the World Heritage Committee, and also what other global citizens can do. So how effective is this new initiative instituted by the World Heritage Committee in relation to Indigenous representation before that committee? And also similarly, a question has been put on that in relation to preserving of Indigenous heritage, but I would ask you if you could keep your reply very brief because of the time issues that we now have. Madam Kabajuni.
Okay. Did you, in the first question, ask me how relevant?
The Indigenous Peoples Forum on World Heritage is. how effective it is in raising awareness?
No, I would say it is too early to say its effectiveness, but what I would say is very relevant. Any platform for the indigenous people is important because the representation and participation of indigenous people in World Heritage is very paramount for their contribution, but also for benefiting, for a platform for them to share their experiences and articulate their concerns.
Thank you very much, Madam Kabajuni. Now, both to Mr. Villalpando and Madam Bensouda, Mr. Villalpando mentioned Mosul. A number of attacks on World Heritage sites have also come hand in hand with illicit removal of movable heritage, so cultural objects, and obviously also removal from the sites themselves. How do you see the role of, or the interrelationship between trafficking and also human rights violations on World Heritage sites, and also violations of international humanitarian law?
Maybe I will go first. Very well, in the many sacrifices I had to make in order to keep my presentation short. One was the decision not to mention in my presentation a very important convention adopted by UNESCO in 1970, which is the Convention on the Means of Prohibiting and Preventing the Illicit Import, Export and Transfer of Ownership of Cultural Property. And this convention has 140 states, and it imposes on states obligations to establish national services for the protection of the cultural heritage and legislative and administrative measures to fight the illicit traffic of cultural goods. In addition to that, this convention is complemented by another mechanism, which was established in 1978 by the UNESCO General Conference, which is known as the Intergovernmental Committee for Promoting the Return of Cultural Property to its countries of origin or its restitution. And this committee facilitates bilateral negotiations between countries for the return and restitution of cultural property. Lastly, the 1954 Convention also entails a number of obligations for the occupying power with respect to the non-removal of cultural property, cultural objects in occupied territories. So there's plenty of international norms on the matter today. Thank you.
Madam Bensouda, I noticed that you have another engagement, so if you are able to answer, we would be appreciative, but if you aren't, we certainly understand.
Well, maybe just to say this, and I'm pleased that Mr. Villalpando has at least given the broad legal framework of what we have today on the destruction of cultural heritage, but also the protection of cultural heritage. And if you look at the ICC statute, the Rome Statute, this is also very clear. And as I said, at least as far as the Rome Statute is concerned and how ICC is to apply these provisions in protecting and also for reasons of accountability for those who actually go out to destroy them. I think the Al-Mahdi case is already an indication of the steps that we are taking as an institution, and which the provisions of the statute I really see as an opportunity for any prosecutor of the ICC, staff of the ICC, especially at the Office of the Prosecutor, and having the responsibility to apply the statute and to apply it by the book. So this is something that my office has also taken very, very seriously. As I said, we see it as an opportunity. We have even gone to the extent of wanting to have a policy based on the legal framework that we have and which we're practicing at the moment. So that policy has been circulated. We've received a lot of feedback from everywhere, including from UNESCO, and also other NGOs, other partners, states parties. again, re-emphasizing the importance of protecting cultural heritage in its tangible and intangible form, and also making sure that those who try to destroy it will think twice, that they would be held accountable for destruction of this very, very significant identity of a people, of a culture. Is not to be taken lightly. And I think as we stand today in ICL and also with ICC provisions as we stand today, I think there is good room for us to be able to make that protection happen. Thank you.
Thank you so much, Madam Bensouda. And thank you to all three speakers for this wonderfully rich discussion on our theme today, the urgency to effectively address gross violations of human rights on World Heritage properties and other protected areas, and also holding people that perpetrate these violations to account is desperately important, the urgency of which has been made clear in our discussions today, but also in the discussions in other webinars in this series, the audios of which you'll be able to access, and we'll be providing you with those links, including a webinar tomorrow as well about addressing human rights concerns on World Heritage sites, again at 10 a.m. Paris time. So thank you to everyone for joining us, and we hope to see you then. And I take this opportunity personally, and I'm sure that everybody in my situation would, to thank Madam Bensouda for all of her work. We know that it hasn't been easy for her, especially in the last few years. We are deeply, deeply grateful for your courage and commitment to World Heritage and to cultural heritage, but also to international justice. So thank you very, very much. And we hope to see you soon in a more elevated position. Thank you.
Thank you very much. Thank you. Bye-bye.
Goodbye. And thank you to all participants again and panelists. Thank you.